Welcome to the MOOC program on Democratic Awareness with Legal Literacy. Today's topic of discussion is right to religion. It is a fundamental right in Part 3 Constitution of India, guaranteed by Constitution of India. It is enforceable against the state. It is stated in this way in Article 25 that it is right to freedom of conscience and to freely practice, propagate and profess, which includes freedom to manage religious affairs. Now, right to freedom of religion, before we discuss about it, its nature and content, some of the things must be cleared. There is a lot of misconceptions about this idea, about this topic. Now, we are aware that our constitution is a secular constitution. Secularism is one of the basic features of Indian constitution. The term secularism was not in the original constitution. It was by an act of amendment, it was brought in the preamble to the Constitution of India. Now, what does it mean, secularism? Secularism in India, already before it was incorporated in Indian constitution, the concept of secularism was there in our original constitution. And the concept of secularism was reflected through two articles. One was right to equality, that talks about, that guarantees the non-discrimination on the basis of religion. There cannot be any discrimination on the basis of religion. And secondly, Article 25, that is right to religion, which says that the state neutrality towards religion and state would ensure that there would be equal opportunity, equal treatment to all religious communities. All religious communities in India, they will have right to freedom of religion. Not only this, they will have equal right to freedom of religion. It's not one particular religious community will get the upper hand or vice versa. It is not. Now, what does it mean, secularism? Secularism in Sanskrit, in Hindi and Bengali, it is termed as, it is translated. The English term is used in this way, dharma nirapekshata. Now, my point is that secularism cannot be dharma nirapeksha. The secularism meaning is that neutrality towards the religion, equal respect for all religions, and not only that, that state would ensure that all get equal opportunity. Secularism cannot mean dharma nirapekshata. Then what does it mean, the term dharma? Dharma means, dharma is a purely religious, non-religious concept. It is a secular concept. Now, and no one can be dharma nirapeksha, state also cannot be dharma nirapeksha. Then what does it mean that with the term dharma? There are 10 commandments of dharma. It is written in Manusmriti. It says like this: Dhriti kshama damasteyang shaucham indriya nigraha dhir vidya satyama krodha dasakam dharma lakshanam. So what are the 10 commandments? Dhriti means patience, kshama means forgiveness, dhamma means self-restraint, asteyang means non-stealing, shaucha means purity of mind, thought and body, indriya nigraha means control of sense organs, dhi means higher level of intellect, vidya means knowledge and wisdom, satyam means truthfulness, and akrodha means non-anger. So do we find any kind of religiosity in the term dharma? Dharma is purely a non-religious concept. A non-religious person can be dharmic, even just vice versa, a dharmic person might not be a religious-minded person. Now, I am referring to Manusmriti, and people have a misconception about Manusmriti, and this time has come to dispel the wrong impression from the concept of Manusmriti. I refer to a very renowned jurist, Justice V.R. Krishna Iyer, a politician come judge, Supreme Court of India, who is also known for his left leniency, but no doubt he was a famous and renowned jurist, Justice V.R. Krishna Iyer. He, in a judgment as a judge of a Kerala High Court, the name of the judgment is Yusuf Rautham versus Swaramma. He says that distortions are inevitable when judicial committee at the Downing Street has to interpret Manu and Muhammad of India and Arabia. The soul of culture law is largely the formalized and enforceable expression of a community's culture norms, cannot be fully understood by alien minds. So what does it say? That Manu has been misinterpreted, wrongly interpreted, and I say that Manu has been construed, misinterpreted, wrongly interpreted with Malachites. And what has he said that cannot be understood and cannot also be appreciated by alien minds, people who have a Western type of orientation, Western type of education. Now, so secularism cannot be dharma nirpekshata. Secularism to the best it can be understood that neutrality towards all religion. It can be said that it can be ideally termed as pantha nirpekshata. Now, point is that then what does it mean, the term religion? Religious purely means that my way of worship, way of praying, my relationship with Almighty, my relationship with God, Allah, whatever, Bhagavan. Now, according to Swami Vivekananda, what does it mean religion? Religion is based upon faith and belief, and in most cases consists only of different sects of theories. Another great Rishi Aurobindo, according to Rishi Aurobindo, religion is that instinct, idea, activity, discipline in man which aims directly at the divine. So if you go by the definitions given by Swami Vivekananda, two great rishis, and Rishi Aurobindo, so religion means only way of worship, way of praying, and my relationship only with God, nothing more. But here dharma is a vast concept, so dharma cannot be equated with religion. So the Bengali or Hindi term of the term religion cannot be dharma. Dharma basically means righteousness, dharma means good conduct. And right to Article 25 guarantees right to religion in this way, that subject to, as I from the earlier discussions we have come to know that no fundamental right is absolute. So accordingly that is also reflected in Article 25, which states that subject to the public order, morality, health, and to the other provisions of the Constitution, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Secondly, nothing in this article shall affect the operation of any existing law or prevent the state from making any law which for regulating or restricting the economic, financial, political, and other secular activities might be related to the religion, and for providing for social welfare and reform. So with that limitation in mind, we have to understood the nature and content of right to freedom of religion. Now again, I refer the Supreme Court judgment A.N. Narayana Dikshitulu versus State of Andhra Pradesh. Justice Ramaswamy says about religion, essentially religion is a matter of personal faith and belief of personal relations of an individual with what he regards as cosmos, his maker or his creator, which he believes regulates the existence of insentient beings and the force of the universe. So same thing, it is also reflected in another Supreme Court judgment, and which has been expressed by Justice Ramaswamy. Now, concept of dharma, as what I have said, now I am referring to the authorities. A renowned jurist of Indian jurisprudence, Justice Rama Joyce, he says that in his book Legal and Constitutional History of India, he says, dharma has been explained to be that which helps the upliftment of living beings. Therefore, that which ensures welfare of living beings is surely dharma. The learned rishis have declared that which sustains is dharma. Now, I refer to another authority, our former President of India, who was a very renowned professor of philosophy, Professor Shankar Dayal Sharma. So, in his lecture in National Law School of India University, Bangalore, in the convocation, he delivered the keynote address. So, according to Professor Shankar Dayal Sharma, dharma means, what does it mean, dharma? The word dharma has originated from the term dhri. Dhri means to uphold, to nourish, to sustain, to maintain. So these are the appropriate words that which are the meanings of the term dhri. So according to Professor Shankar Dayal Sharma, he referred, so dhri means which upholding, like that. In the Varna Parva of Mahabharata, verse 58 in chapter 69, dharma is for stability of society, the maintenance of social order, and the general well-being and progress of mankind. Whatever conduces to the fulfillment of these objects is dharma. So it means that dharma, only with the virtues of dharma, the human beings, the society can develop, can be maintained in their interrelationship with society and with all other living creatures and non-living creatures. So it is for the sustenance of the society, for the sustenance of the whole earth, whole living beings, non-living beings, and for the development. Now, one important point I like to highlight, that people are under the wrong impression and always use that Hindu religion. Hindu is not a religion. A very famous case, Ramakrishna Mission, Brahmachari Siddheswar Bhai versus State of West Bengal, by referring to a previous Supreme Court judgment, a constitution bench judgment of Supreme Court, it says that Hinduism, that is Hinduism, is not a religion, it's a way of life. So when according to Supreme Court, a 5-judge constitution bench, Supreme Court says, when we think of the Hindu religion, we find it difficult, if not impossible, to define Hindu religion or even adequately describe it. Unlike other religions in the world, the Hindu religion does not claim to have one prophet, it does not worship any one god, it does not subscribe to any one dogma, it does not believe in any one philosophical concept, it does not follow any one set of religious rites or performances. In fact, it does not appear to satisfy the narrow traditional features of any religion or creed. It may broadly be described as a way of life and nothing more. So in the Hindu society, we don't have one holy book, one prophet, one particular one god, even one philosophical concept. We have 6 philosophies, and we don't have even even the Upanishads, and we also don't have any kind of do's and don'ts. The rituals you have to observe, you need to observe. It is not. There is complete relaxation. So, and the concept of religion, the definition of religion is not applicable to the Hinduism and Hindu society. That is the reason it says it is a way of life. Now, in that way, now while talking about the right to religion, it means that its contour, its peripheral limit, as already I discussed that it was not an absolute right, and what are the restrictions and on which grounds there can be restrictions. As we are discussing about, to know understand the extent and limit, nature and scope of right to freedom of religion, we must keep in mind the actual meanings of these terms like Hinduism, religion, dharma, secularism, like that. Now coming to the point that what is the extent of the protection, what is the limit over the right. Now a very important Supreme Court judgment, Commissioner of Police versus Acharya Jagadishwarananda Avadhut, it says, the Supreme Court says, the protection guaranteed by Article 25 and 26 of the Constitution is not confined to matters of doctrine, of belief, or faith, but extends to all acts done in pursuance of that religion, and therefore contains a guarantee for rituals, observances, ceremonies, and modes of worship which are very essential or integral part of religion. So it means that only the belief part of it, which contains the religious belief, religious philosophy, like that, but even then all the rituals, ceremonies, modes of worship, these are also protected. Now to what extent that protection can be guaranteed? What constitutes an integral part or essential part of religion has to be determined with reference to its doctrines, practices, tenets, historical background, etc. of the given religion. So it means that whether it is essential part of that doctrine or belief or faith or conscience, or this kind of practices, whether these are considered as essential practices, these are to be decided on the basis of the religious tenets, practices, historical backgrounds and doctrines of that particular religion. Now in that case, second part of the judgment says that It is upon the, now what is that test? Essential religious practice, essential religious belief. And it has to be distinguished from non-essential part. Non-essential part of religious belief or the doctrine or conscience, non-essential part of the religious practices are not protected. So how it is to be determined, how it is to be decided? It is upon the cornerstone of essential parts or practice of the religion that the superstructure of a religion is built, without which a religion will be no religion. Test to determine whether a part of the religion or part of the practice is essential to the religion is to find out whether the nature of the religion will be changed without that part of the practice. If the taking away of that part of the religious belief or that part of practice could result in the fundamental change of the character of that particular religion or in that belief, then such part could be considered as an essential part of religion, an essential practice of religion. There cannot be any additions or subtractions to such part which will change its fundamental character. So those essential parts or essential practices without which the religion will not be complete, and that particular religion will be losing its own character, own nature, own philosophy, own belief. So that is protected, that cannot be regulated, that cannot be interfered with. Now question is, I will be giving some living examples, like in Muslim society the practice is there talak, talakul viddat and talakul sunnat. Now talakul viddat, it does not need any reason or any particular time. It is not even specifically mentioned in Holy Quran and Hadith. What is there in Holy Quran that is about talakul sunnat? It says that, I'll be reading out some of the verses from Holy Quran. It says that when ye divorce women, divorce them at their prescribed periods and count their prescribed periods and turn them out of their houses, not shall they leave except in case they are guilty of some open lewdness. Those are the limits set by God, and any who transgress the limits of God does verily wrong his own soul. Second verse, thus when they fulfill their term appointed, either take them back on equitable terms or part them on equitable terms, and take for witness 2 persons from among you, endued with justice, and establish the evidence before God. Such is the admonition given to them who believes in God and the last day. Last one, if a fear there is a breach, them twine, appoint 2 arbiters, one them from his family and other from the other family. If they wish for peace, God will cause for the reconciliation. So what we are finding, that is, the Holy Quran also says that there should be a justified reason, and if there is a breach of the matrimonial conduct. So Quran does not say that it is about arbitrary power, a whimsical power of the husband to dissolve the marriage. So there has to be a breach from the side of the wife, and there has to be a justified cause, and then there has to be a reconciliation process, and then that reconciliation process, who would do? One arbiter and 2 persons selected from 2 families, they will try to sort it out. If they fail, only then the divorce can be effected. And so this is the specific instruction and mandate of the Holy Quran. So, and when we talk about that, talakul viddat is a essential practice or essential part of Islam. So then in that recently a constitution bench has rejected this argument that it cannot be essential part and practice of Islam. Justice Kurian Joseph, in that Shaira Banu versus Union of India I was referring to, he says, these instructive verses do not require any interpretive exercise. They are clear and unambiguous as far as talak is concerned, talakul viddat is concerned. The Holy Quran has attributed sanctity and permanence to matrimony. However, in extremely unavoidable situations, talak is permissible. But an attempt for reconciliation, and if succeeds, then revocation, are the Quranic essential steps before talak attains finality. However, on the statement that the triple talak is an integral part of the religious practice, I respectfully disagree with the Chief Justice. Merely because the practice has continued for long, that by itself cannot make it valid if it has been expressly declared to be impermissible in Holy Quran. And again he says, therefore, in any case, after the introduction of 1937 Act, no practice against the tenets of Quran is permissible, hence there cannot be any constitutional protection to such a practice, and thus my disagreement with the learned Chief Justice is there. Now, point is that I am from a place, from a district, is Kachar district. So a case went to Guwahati High Court in 1980 when Justice Baharul Islam was the Chief Justice of Guwahati High Court. First time the case which came from our district where my university is situated. So the Justice Baharul Islam says that this kind of talaq, without any justified reason, without any justified cause, without any kind of reconciliation process, this talaq is not permissible in Islam. The Holy Quran does not allow this kind of practice. So in 1980, Justice Baharul Islam's judgment, when subsequently he became Chief Justice of Guwahati High Court, in another case he pronounced the same verdict. Now, after Justice Baharul Islam's verdict, in 1980 and 1981, other high courts like Bombay High Court in Dogdu versus Rahim Bai, Chennai High Court and many other high courts finally came to the conclusion that this kind of arbitrary unilateral talaq without any justified cause, without any reconciliation process is not permissible in Holy Quran. Now I am referring to Justice Nariman in Saira Banu versus Union of India. He is of the view that applying the test stated in Acharya Jagadishwarananda, it is equally clear that the fundamental nature of the Islamic religion as seen through an Indian Sunni Muslim's eyes will not change without this practice. Though permissible in Hanafi jurisprudence, yet that very jurisprudence castigates triple talaq as being sinful. It is clear therefore that triple talaq forms no part of Article 25. Now, in 2022, there was again a Supreme Court judgment, Shamimara versus State of UP. Here, the Supreme Court also, by quoting Justice Baharul Islam's judgment, that is Rukia Khatun versus Abdul Khalik Lashkar, Court says that correct law of talaq as ordained by Holy Quran is that talaq must be for a reasonable cause and be preceded by attempts at reconciliation between the husband and the wife by two arbiters, one from the wife's family and other from the husband's family. If the attempts fail, talaq may be effected. It refers that Justice Baharul Islam's judgment in Rukia Khatun versus Abdul Khalik. It says, just a division bench of Guwahati High Court says that talaq must be for a reasonable cause. It must be preceded by attempt of reconciliation between the husband and the wife by two arbiters, one chosen by the wife in that way. So finally what we have found that this talaqul biddat that is practiced in Islamic society, a group of women, they challenge the constitutional validity, and finally Supreme Court has come to the conclusion that this kind of talaqul biddat is not permissible in Quran. It is not even it is not mandated in Holy Quran. What is there, that is talaqul sunnat, which is, and talaqul sunnat means that there must be justified cause and that there must be reconciliation. So that is legal and that is constitutional. But even then, this kind of talaqul sunnat is a it is at the instance of the husband. Here the involvement of the judiciary is not there. It is extrajudicial divorce. So time has come to regulate this and to make it a judicial process, legal process, where intervention of the judiciary would be there, likely to many other Islamic countries where this kind of even at the instance of the husband, talaqul sunnat has been prohibited or even restricted, and the law has been enacted, and judiciary has also given the power to say final word in this matter. So it is a judicial divorce, unlikely to India, where still it is extrajudicial divorce. Again, a famous case, Muhammad Hanif Qureshi versus State of Bihar, where there is a constitutionality of the law was challenged, that is the sacrifice of cow in a Baqar-Eid day. So, according to Supreme Court, a 5-judge constitution bench, Supreme Court says that no authority from Holy Quran or Hadith has been cited which says that the sacrifice of cow slaughter on Baqar-Eid day is essential religious practice in Islam. So according to the Supreme Court, it says that no reference is made in the petition to any particular surah of the Holy Quran which requires the sacrifice of a cow. We, however, find it laid down in Hamilton's translation, Hidayah's book, that it is duty of every free Musliman arrived at the age of maturity to offer sacrifice on the Eid Qurban or festival of the sacrifice. The sacrifice established for one person is a goat, and that for 7 a cow or a camel. It is therefore optional for a Muslim to sacrifice a goat or for one person, or a cow or camel for 7 persons. So by interpreting this, that Hidayah, it is not written in Holy Quran or Hadith, it is written in Hidayah. It does not appear to be obligatory that a person must sacrifice a cow. The very fact that option seems to run counter to the notion of an obligatory duty. So when the book says that it is a kind of option is given, so as far as option is concerned, it cannot be accepted as obligatory duty or mandatory or essential religious practice. I come to the next point, that is Indian Young Lawyers Association versus State of Kerala. It is about Sabrimala temple case, where the women belonging to 10 years to 50 years, their entry is restricted. They are prohibited from entering. They are prohibited for worshipping, and they are to enter into the sanctum sanctorum. So the review petition is on, and Supreme Court will obviously come up with a final conclusion. In that judgment, Justice Indira Malhotra has given a dissenting view, but majority view says the exclusionary practice being followed at the Sabrimala temple under Rule 3B, Kerala Hindu Places of Public Worship Authorization of Entry Rule, so violates the right of Hindu women to freely practice the religion and exhibit their devotion towards Lord Ayappa. This denial denudes them of the right to worship. The right to practice religion under Article 25(1) is equally applicable to both men and women of all age groups professing the same religion. Now, secondly, the Supreme Court says the exclusionary practice being followed at the Sabrimala temple cannot be designated as one, the non-observance of which will change or alter the nature of the religion of the Hindus. Besides, the exclusionary practice has not been observed with unhindered continuity, as the Devaswam board itself had accepted before the High Court that female worshippers, to visit worshippers of the age group of 10 to 50 years used to visit the temple and conducted pujas in every month for 5 days for the first rice ceremony of their children. And finally, the Supreme Court comes to the conclusion that in no scenario it can be said that exclusion of women of any age group could be regarded as an essential practice of Hindu religion, and on the contrary, it is an essential part of the Hindu religion to allow Hindu women to enter into the temple as devotees and followers of Hindu religion and offer their prayers to the deity. Now, another side of the argument that Lord Ayappa practices celibacy. So it means that and if the Lord also has a right to choose that from whom the Lord Ayappa would be worshipped, would get the worship, and whom not. So the God also had a privacy that to allow and not to allow. So and that also the judges are keeping in mind while coming to a final conclusion on this issue. Then N. Adityan versus Travancore Devaswam Board. It is a very famous case. It is about that it is the decision of the Kerala government that to appoint the pujaris, purohits from other so-called non-Brahmin communities. When the constitutional validity was challenged by saying that only the people belonging to Brahmin community have the right to be appointed as pujaris or archakas, the Supreme Court has said that no, it does not matter. It is not the essential religious practice. The people, well-trained people belonging to all other castes, all other burners, or everyone. So if they are well acquainted with the system, if they are well versed with the system, and if they are well educated, and if they are well trained, all people belonging to caste does not matter, varna does not matter. If they are trained and well educated and they are well versed with the system, they have got the training, they can be appointed as the pujaris and archakas of a temple run by the government. So this is, and non-doing this is not an essential religious practice. So as time is short, I am not reading out the final judgment. You can see it in the slide at the time of when you will have access to my lecture. So now again there is I will be concluding the Acharya Jagadasharananda versus Commissioner of Police, where the Tandava dance that on the public places by taking human skulls. So the Anandamargi community, they challenge the government's ban, the constitutional validity of this ban. Supreme Court says that no, that Tandava dance on the public places by taking human skulls on the hands cannot be considered as an essential religious practice. It can be accepted as an essential religious practice if you do it at home, but this the Anandamargi, the religious tenets and other matters related to that religion does not say that this kind of Tandava dance must be performed on public places. So this ban is legal, this ban is constitutional, and it is not the essential religious practice of the Anandamargi, that religious denomination, to perform this dance in openly on public places. And then this is about wearing hijab is a essential religious practice or not. Kerala High Court says that no, it is not a essential religious practice in Islam. I'll take 2 more minutes. That a practice claimed to be essential to the religion has been carried on since time immemorial or is grounded in religious text per se does not lend to it the constitutional protection unless it passes the test of essentiality as is judged by the courts in their role as the guardians of the constitution. Now point is that what High Court has referred to, that okay, there are some instructions about the dress code, but High Court says that, and if the Muslim women do not follow this dress code, the way hijab and other kind of burqa, so there is no punishment prescribed. So when no punishment is prescribed, so that cannot be accepted as an essential religious practice. So it means that it was optional, it is a mere directory in nature. So finally, I like to conclude by saying that now point is that I'll just read out and I'll give a small presentation. Law is an organic social institution and not just a black letter section. In order to be living law of the people, it marches with the ebb and flow of the times, either through legislative action or judicial process. Constitution, being the fundamental law of the land, has to be purposely construed to meet and cover changing conditions of social and economic life that would have been unfamiliar to its framers. It is the court has Karnataka High Court has come to this conclusion in Resham versus State of Karnataka, where hijab ban was challenged and it was dealt upon by the High Court. The point is that purpose of law is to initiate social reform, and in case of social reform, obviously even if it is essential religious practice, even if it is essential religious part, that also can be interfered with, can be regulated. So the purpose of the law is to give justice, is to render justice, and one of the purposes from the sociological perspective, that is to bring social change, to bring social reform. So this kind of derogatory practice, which not only violates right to equality of the women, it impairs the dignity of the women, even it does not form part of the essential religious practice or essential part of the religion, but in the name of religion, the women and others, they have been they are not allowed to exercise all their fundamental rights and all their liberty, all their fundamental rights which are guaranteed by the Constitution. So time has come that law should perform its role, and the Supreme Court also takes the account, and parliaments also should keeping it view, also must come up with some kind of, that one point is that uniform civil code. What matters, that is right to that marriage, divorce, maintenance, succession, adoption, guardianship are not the religious matters. These are all secular matters. These are all civil matters. So like take for example, for Hindu women cannot be the guardian. First preference the father gets. In other religious communities, for Muslims, Christians, Parsis, mother cannot be the natural guardian at the first instance. Father gets the first preference. So absolutely there is inequality, there is violation of right to equality of the women. So to protect the fundamental rights of especially the women who are the victims of discrimination either on the basis of religion and on the basis of discrimination, either on the basis of gender they are discriminated and on the basis of religion they are discriminated. So time has come, by keeping in view the Supreme Court judgments, like requesting the legislatures to have uniform civil code in Muhammad Ahmad Khan versus Shahinara Begum, or Shahbanu Begum, or Sharla Mudgal versus Union of India, Lily Thomas versus Union of India. So Parliament also should come up with a legislation to make a uniform civil code which does not in any way violate the core part of religion of any religious community or any essential religious practice of any religious community. We have a state, Goa, there is a uniform civil code. All persons belonging to the Goa, Hindus, Muslims, Christians and Parsis, they are governed by uniform civil code. So in the way, same thing should be applicable. Time has come to, by keeping in view the mandate of directive principle of state policy, Article 44 Constitution of India, we must have a uniform civil code which does not in any way violate anyone's religion, core part of religion or essential religious practice of religion. Thank you so much.